First, I want to say that everyone, we've got a pretty full agenda here today. Feel free to chat in your questions, but for the most part, we're going to defer those to the end to ensure that we complete the PowerPoint for those who need to leave by 11 a.m. for other obligations. Mark and I will stand by as best we can to answer your questions. Second, of course, the disclosure, especially as I look at some of the attendees, this is not legal advice. For legal advice on specific issues, you should contact your labor counsel, whoever that might be, your city attorney, your county counsel, etc. So let me just tell you briefly, around the country right now in Oregon, we're hearing demands to defund the police. What does that really even mean? The term's being used loosely and in many different contexts. It is often used to mean anywhere from removal of law enforcement to reduction or reformation of the same. No matter what the context, local governments need to be aware of the potential labor impacts with your unions. You should consider the labor implications as to various changes, as well as the new Oregon legislation recently passed during the most recent Oregon legislative special session. Questions come up, for instance, can you eliminate your school resource officers? Can you reform your use of force policies? What about across the board reduction of law enforcement budgets? All of those decisions can carry various labor law implications and responsibilities. Those are based in the law or depending on your current collective bargaining agreement with your law enforcement unions. Local governments have also been receiving public records disclosure requests regarding police use of force from various concerned action groups. Do you have to disclose the requested records? Unfortunately, if your jurisdiction does not properly consider the labor impacts, you could face potential unfair labor practice complaints and so much more. The best and most cautious approach is to have an open line of communication with your labor counsel, as well as open communication with your union representatives. Communication can go a long way to avoid future and unanticipated legal issues. Knowledge of your legal obligations is also very important. So many of you who are not directly involved in your union matters, whether you be a council member, a city manager who defers to their HR, you might have your own labor department within your jurisdiction. This is hopefully a webinar that's going to help you put up some red flags to just say, hey, wait a minute, I better slow down. I better run this by the person who represents my labor interests and make sure that I'm not misstepping. So we hope this presentation will help you to better understand the potential labor impacts as you make those bigger decisions. So defund the police, what does it really mean? When I first started seeing this, I was kind of aghast. And I thought, what do you mean defund the police? That means getting rid of all the police officers? Mark?
Oh, sorry, that slide hadn't come up, but yeah, so what does defund the police really mean? And then really for our purposes, how does it intersect with your union obligations? You know, are we, do we have bargaining obligations? Do we have midterm bargaining obligations? We want to avoid unfair labor practice complaints. So that's the focus is defund the police and how the decisions that you are considering, how those interact with your labor obligations.
Great, thanks. When I went through, and I've been following various news articles and legislative attempts for months now. And as I started to also work on this presentation, I found myself putting this defund the police into three aspects. We're either talking about removing, reducing, or reforming. So those are going to be our focus today. But first, let's not forget our focus. I want to be very clear about that. Is our focus here political decisions? No. You do what you need to do regarding the political decisions, regarding your school resource officers or your use of force policies. Is it social accountability? No, we're not doing that here today either. This is not about Black Lives Matter. This is not about oversight boards. You do what you think is best. Is this a budgetary presentation? No. Again, this is not about reducing budgets or how to go about it and whether you should. Today, our focus is your labor impacts. And yes, that's what it is. Do I need to discuss or bargain this with the police union? And notice I put in discuss. Just because we meet with the union and we might not have a bargaining obligation does not mean that we're prohibited from having non-bargaining discussions to try and see if we can be on the same page and at least go forward in a semi-united fashion.
All right, so a quick refresher on the some of the aspects of the Public Employee Collective Bargaining Act, or PECPA. The act requires a public employer to bargain over mandatory subjects of bargaining related to a public employee union. So what is a mandatory subject of bargaining? We can keep moving forward, Diana. We're going to get into that a little bit. So under the PECPA, collective bargaining is defined as an obligation of both parties, so of the employer and of the union, to meet at reasonable times and confer in good faith regarding mandatory subjects of bargaining. Next slide, please. Yeah, thanks. So a mandatory subject is a proposal within the definition of employment relations that is neither prohibited nor permissive. And employment relations is defined in the PECPA, and it includes but is not limited to direct or indirect monetary benefits, so anything to do with money, hours, vacation, sick leave, grievance procedures, discipline and discharge processes, and other conditions of employment. And I think, Diana, you're going to get to what that other conditions of employment is.
I am. And let me just say again, maybe at the 10,000 foot level for the attendees, why is this important? It's important to identify whether or not you have a mandatory obligation to bargain, because if you do have that obligation and you don't bargain, there can be legal consequences. Now, Mark also mentioned that there are also things known as permissive subjects of bargaining. There's no harm or foul in talking, for the most part, to the union about those, even if you don't have to. And there are also no legal consequences for the most part if you don't. So that's why a mandatory subject of bargaining is so important, to identify that, to make sure that you meet your obligations to avoid legal consequences. So other than the specific mandatory subjects of bargaining, which there are a few that are lined out very specifically, but for the most part, I think, especially for some of the lawyers on this presentation, there's a lot of gray in the law. And because there's some gray, the ERB, the Employment Relations Board, who is the administrative agency who enforces the Public Employees Collective Bargaining Act, they have developed a balancing test for determining whether or not a bargaining subject or this other condition of employment is mandatory. And the test is whether or not subjects have a greater effect on management's prerogative, more so than it has on the employee's wages, hours, other terms, or conditions of employment. And again, this is just an overview. And that's important to know. It's a balancing test. It looks at the totality of the circumstances. But the ERB also looks at impacts. And that's one of the places you're going to run into in this overall scheme of defunding the police, is whether or not your decisions that you might be making, even those decisions themselves might not be mandatory, the impact of your decision could impact a mandatory subject of bargaining: wages, employment, working conditions. So the test there is, if a bargaining subject falls within one of the specifically listed subjects, the balancing test doesn't need to apply. The subject is deemed to be per se mandatory. Wages, per se mandatory. But in addition, if a proposal impacts a mandatory subject of bargaining, the impact itself, although the decision not, but the impact must be bargained. All right, so that's our overview, you guys. Now let's get back to this current state of affairs. And this is a picture I took off the internet of one of the demonstrations heading up I-5. You can see the beautiful Pacific Northwest there in the back, and you can see all of the protesters. So the question becomes, our first R, remember, remove, no more police. Is that really likely? It's not likely, but it could happen, and some folks have talked about it, and we'll get to that. But then we need to look at, don't forget, what if this happens? What happens when the good ones say, I've had enough, and walk away? So those are things to ponder in your decision. Whether or not you have a mandatory obligation to bargain with your police, you need to ponder sort of the intersection, if you will, of public demand for accountability versus law enforcement satisfaction and safety. If you reduce your forces too much, is that a safe working environment? If you reduce your opportunities or tighten the belt too much, are the good ones going to walk away? So, and then an interesting thing when I was researching it, and I can't help but smile, but we've got an internal fight with the unions. I saw an article, it was talking about the local unions within the global bigger AFL-CIO are pushing to oust some of the police unions. And I took a quote from one of the articles: several local unions have moved to oust police unions despite the Federation, and that was the AFL-CIO, Federation's approach, where they believe that collective bargaining can be used for police reform. And we're going to talk about the reality of that and how this last special legislative session was different than any I've ever seen in my career before, as far as the movement in some sort of police reform and accountability. So when you look at whether or not there's now also a labor movement split, the local unions, as I said, are defying leaders of the AFL-CIO who have been fighting to cut ties with labor's law enforcement and have been stressing the collective bargaining avenue to counter the excessive use of force. And the idea of collective bargaining to do that is, in my humble opinion, not very realistic. I think going the legislative route, as you'll see in a while, has been much more effective in getting overall consensus so that we have consistency across the state. So now let's talk a little bit about the labor impacts of eliminating the police. Remember, we're back on the whole remove R. We'll get to the other ones in a little while. The labor impacts of eliminating police. So whether or not, let's say you decide you want to get rid of your police, you might either want to go to a, I don't know that you can do this, but maybe you want to go to a non-law enforcement jurisdiction. Well, or maybe more likely you want to defer or subcontract out with the sheriff's office for coverage or something like that. Let's talk about what that looks like. Services that are provided by a jurisdiction, that's a decision that is a management right. All right, so that's one of those, what Mark called a permissive subject of bargaining. You don't have to bargain necessarily about the decision of whether or not you want to have a police force or not. Now, there's a big caveat, and we're going to come to that. If the jurisdiction is subcontracting out the work, then you have an obligation to bargain over sometimes not only the impact, but also the decision. And we're going to talk about that. So now let's go ahead and go to the much more likely reduce, all right, as opposed to removal. And when we talk about the reduction, that's our much more likely outcome. But what does it mean? Budget reductions, elimination of specialty teams. And then another thing that we're seeing right now is alternatives to police response. I'm going to pull up this little note here that I had that I wanted to read to you. I found an article the other day, and it was about the police force in Austin, Texas. Quote, only about 1/5 of the 911 calls to police in Austin, Texas. Now, remember, they've got a large university there and some other things, are for crime. 1/5 for crime, and less than 1% are for violent crime, according to this report by a company called Datalytics. It was sponsored by the Austin Justice Coalition. The report recommends having people other than the police respond to mental health calls and reducing police response to traffic accidents where no one is injured. Okay, so let's move on here. This was a headline that I saw. Community organizations and advocates mixed about defunding the Seattle Police Department. That was the headline. But when you read the article, it's clearly talking about a reduction, not a defunding. So again, my warning to you is always be careful when someone is using the term defund to have them more define what do they mean. I like my 3 R's. Feel free to use them. Reduce, remove, reduce, or reform. And from the article, Seattle, a strong majority of Seattle City Council is in favor of slashing the police budget by 50%. The police chief Best, love that last name, warned. He said, if you do that, pivotal teams like homicide, violent crime, they're going to be cut. Traffic and SWAT, they'll be done away with altogether. And then, and you know, now that I think about it, Carmen, that could be a female too. Anyway, he or she said, I do not believe we should ask the people of Seattle to test out a theory that crime goes away if police goes away. That is completely reckless. And I started to go off on a tangent at one point in putting together this PowerPoint. And those of you who know me probably chuckle silently at the thought of Diana going off on a tangent. I mean, that would never happen. But anyway, I had to not do it because it was a big and long tangent about some of the studies that they've done in other countries where the police force has been eliminated. And that's something, again, that's not going to be a scope of this presentation, but something that you definitely want to think about if it's anything you're considering. So let's talk about alternatives to police response. I remember when I first started dealing with this with fire departments a long time ago, when, you know, fire departments, for the main part, used to have fire trucks. But now, for the main part, they have a lot of those EMT vans, paramedic vans. And the fire department had to start looking into alternatives years ago as their medical call volume increased and their fire calls remained steady or even decreased. And so that might be what we're facing now with our police. Now, here's where we come into, again, subcontracting. Remember, I talked about that earlier. Let's look at what is subcontracting and what are your obligations. An employer's duty to bargain subcontracting decisions cannot be judged apart from its duty to bargain over the effect of those decisions. The Employment Relations Board has adopted what they call an all things considered approach to determine whether or not an employer has the duty to bargain over the subcontracting decisions. So not just the impact, but also the decision itself. And again, if you're facing that, consult with your labor counsel. There are a lot of cases and a lot of rules about subcontracting. The ERB takes this balanced approach where they try and look at the employer's right to manage its business against the effects of the decision. So we saw a lot of those probably about 10, 15 years ago with wastewater treatment plants. There were quite a few jurisdictions that decided to subcontract that out. We've also seen it with libraries. We've seen it with quite a few mental health type issues with the counties. So they look at that against the effects of the decision on the bargaining unit in light of all the relevant circumstances. And they look at various different aspects of that decision. At the end, it's a factual determination. In some circumstances, the subcontracting decision can be found to be permissive, and in others, it may be mandatory. And so it's important to meet with your union, see if you can get on the same page. If you can't, you can go to the Employment Relations Board and ask them for a declaratory ruling before you get in trouble. Say, is this or is this not something that I need to bargain? Notice of subcontracting. So obviously, if you're going to do this, you have to provide notice to the union, and it has to be a clear and unambiguous statement that the employer is proposing or will propose a plan to contract out bargaining unit work. So you can anticipate changes and give notice prior to the actual plan going forward. A clear and unambiguous statement that the employer stands ready to bargain over such a proposal prior to any decision being made. And the union can always waive that and not enforce it and say, you know, we don't care. Not very likely, but it has happened. All right, so now let's look at some of these alternatives now that we've talked about if you're going to actually subcontract, you might need to bargain that. But let's look at some of the alternatives. So right now, in Eugene, I've been focused on this group called CAHOOTS. They're a Eugene-based mobile crisis intervention program. And let me just read you a couple statistics. The program often responds to mental health crises as well as the needs of the growing homeless population. It has been touted for both its local popularity and cost effectiveness. It has saved, according to this newspaper article, an estimated $14 million in local emergency medical system costs in 2019 alone. And we're starting to see this around the country. Now, if you are contracting out to something like CAHOOTS, you're going to have a subcontracting bargaining obligation. But if you're just giving away the work and you're not maintaining any control or direction over that work, you might not have to bargain over that. Obviously, you're probably going to be reducing your force, however, if you do. So let's look at another few more things I found. This is from CAHOOTS itself. They said, we're very aware that there's lots of folks interested. It's both media that wants to get the word out and are just learning about CAHOOTS, and stuff like that. But I noted, they also said, but it's also a lot of city governments, a lot of community activist groups that are contacting them. Law enforcement officers at times are reaching out for their information. Now this is out of New Mexico. The mayor proposes a new public safety department. That sort of caught my attention. And here's what he says. He says a public safety department that would send trained professionals to respond to certain calls for help in place of armed officers. Now it's going to be interesting to talk about, well, do we still dispatch those? Who's going to be dispatching that stuff? That's going to be something you'd have to look at in your subcontracting issues. So it's not just Oregon. This one out of New Mexico, it was the Albuquerque Community Safety Department, and the mayor described it as having social workers, housing and homelessness specialists, violence prevention, diversion program experts who would be dispatched to homelessness and down and out calls, as well as behavioral health crises. You know, in some ways we saw this, 20 years ago, maybe it wasn't that long ago. Well, I think it was about 20 years ago when they developed, remember they developed drug court. Never used to be such a thing as drug court. I mean, a misdemeanor possession was a misdemeanor possession. And then they developed these drug courts where first time low-level offenders, usually for possession, could go in and they'd be sort of siphoned off the main system of corrections, and they'd get a specialized type of assistance. So I think that might be sort of the next step that maybe we're looking into in police. Mark, do you want to talk a little bit about the school resource officers?
Yeah. So school resource officers, or SROs, have been one of the hot topics in the news across the country of whether or not officers should be in the schools. This slide's talking about Portland and Mayor Ted Wheeler. He, along with, I believe, the Portland Public School Superintendent, said that they're going to end the program entirely. It's a move that activists have been demanding, and in Eugene, where I live, the 4J school district, the school district recently extended the SRO program. I guess the contract was due to run up at the end of June, and they extended it until the end of the year, till the end of December, pending some sort of safety study that I believe the school district is going to do. And so whether or not SROs are going to be a part of the Eugene school district is still up in the air. But from what I read, it doesn't sound as if cops are going to be in the Eugene school district anymore. But again, that's the decision for you all. We are here to talk more about the labor impacts of a decision of whether or not to pull the SROs from the schools. And really the big question is there a duty to bargain with your union if you are deciding to pull the officers from the schools? And so we think the answer is likely there is no obligation to bargain, as subcontracting, as this was, I guess, already subcontracted out. And so it doesn't appear as if there will be a duty to bargain on that decision of whether or not to pull those officers out of the schools. But again, if you get a demand to bargain from the union about that, process it. Contact your labor help. Refer to your CBA. Refer to the contract that you have with the school of what it may or may not require for the SROs. Often, also, I've seen it's the school districts choosing to, whether it's cancel the contract or however go about it. It's the school district choosing to get the SROs out of the schools. It's not necessarily the police department making that decision.
Yeah, and I think a lot of these decisions would hold over as well for like the jurisdictions who have a college or university in their jurisdiction where the college or university has contracted with the law enforcement agency for police presence on their campus. That school or college can end that contract with you. And Mark and I talked about, one of the things that will happen too is you'll have to be sure to follow very closely your layoff, seniority positions if that ends up to coming down to cutting positions. And remember, for the most part, labor unions are all about seniority. So just be sure to look at that. All right, so let's get now to our third big R. We've gone remove, we've gotten reduce, whether that's sending out alternative types of responses, et cetera, cutting out positions. Now let's look at reform. And I found this lovely little protester. I noticed she was wearing her mask, good girl, and said, we need police reform. And I really think in a lot of ways, that's what this defunding movement has been more about, was police reformation. So we're going to be looking at oversight that's being created right now in the state of Oregon. There's some oversight going on in the federal level as well, but that's beyond the scope of this presentation. We just won't have time. As you can see, we're already halfway through our time, and we still need to cover the new legislation. So we're going to keep on moving here. So on this slide, this was the post that I saw inviting me to take an online survey. So I took it just to see what would happen. It said, it was from Pamplin, Portlanders are speaking up about police reform. Where do you stand on the issues? And so I took the poll, and it said the questions: should the Multnomah County Sheriff's Office take over the Portland Police Bureau? How do you favor modifying police departments? And the choices were reducing, increasing funding, shift funding to alternative services, or eliminating the police department altogether. Now, I didn't hit send, so I don't know what the results were, if they would even give it out. But just the poll itself, I thought was very interesting to see that out there. I found this little cartoon, and it said, this is what we mean when we say defund the police. It simply means to reallocate resources to agencies that are better equipped to handle and prevent certain societal problems. So again, one of my reminders of be careful that we're understanding the language. So let's talk about reform in Oregon. And for reform in Oregon, the Oregon lawmakers for both parties, I mean, this was amazing for me to watch. One of the best and most recent bipartisan efforts I've ever seen, along with Governor Kate Brown. Everyone seemed to agree it was time for the state to pass police accountability laws. And when we talk about reform and accountability, some interesting sort of quotes, although they previously addressed well-documented concerns such as the frequency of arbitrators overturning police discipline in high-profile use of force or racial bias cases, the proposals got little traction. Ladies and gentlemen, I can tell you for 20 years, I've been trying to help labor management at the legislature during their legislative sessions. And it was always just such an effort and futility. I mean, there were a few times we made some ends, but for the most part, especially this bill about arbitrators overturning police discipline, never got any traction. The unions always fought them. And we had various legislators who would not go up against the union's objections. The law enforcement unions put up fierce fights, and other labor groups backed them. And remember, this goes back to that sort of divide now, is some of these other labor unions are saying, hey, you know what? We've protected you all of these times, and that ship has sailed. This is over. So, Mark, why don't you tell us about what happened at that last legislative special session? And you might even want to at some point mention to everyone we've got a second one coming up.
Right. So the first special session, 24 bills were passed, 6 of which dealt with police accountability measures. There's a second special session starting next week. It was originally, the plan was to focus on the state's budget, but now there's, news reports that there might be more police accountability, either changes to these 6 that we're going to talk about or new ones altogether. So while we're going to talk about these new ones, which are in effect, keep your eye out starting next week for changes. So the first one is, and arguably the biggest for, in the labor world here, what we're talking about is Senate Bill 1604. And Diane, yeah, there we go. So the arbitration reform and the disciplinary matrix. So this bill has a couple of key provisions. The big one being that it restricts arbitration award from ordering disciplinary action that differs from the discipline imposed by the law enforcement agency if these 2 things occur. 1, if the arbitrator makes a finding that the misconduct occurred consistent with the law enforcement agency's finding of misconduct. And 2, the discipline imposed is consistent with the provisions of a discipline guide or a discipline matrix, which was adopted by the agency as a result of collective bargaining. So again, 1, we have to have the arbitrator make a finding that the discipline was consistent with the law enforcement agency's finding. And then 2, the discipline must be imposed consistent with this guide or this matrix, which we're going to get into next. But that guide or matrix must have been adopted through collective bargaining. So another key provision, the discipline matrix or the guide is now a mandatory subject of bargaining. It is now included in the definition of employment relations for law enforcement agencies. So what is a discipline guide or a discipline matrix anyway? That was my first question. So the bill itself does define what these are. And so I read them first and I thought, oh boy, those kind of sound the same. They both mean a grid used. The grid somehow is designed to dictate what the level of discipline will be. So I read them again and I started to underline what the differences are between a guide and a matrix. So a guide has parameters for the level of discipline, whereas the discipline matrix does not talk about parameters. The matrix talks about discipline being imposed from the intersection of, you got a column on the left that has the levels of misconduct. You go down, you find that one, and then you move across the grid, and that's the discipline to be imposed. Whereas the guide has parameters which also take into account aggravating or mitigating factors. So it seems to me that the guide has a little bit more discretion for the employer on what level of discipline to be imposed. So as we said, or as I believe I said, these bills are effective now, but this one in particular only applies to collective bargaining agreements that were entered into on or after the effective date of the bill. So if you're midway through your 3-year contract, this bill and this arbitration reform will not apply to you.
And again, Mark, this is something that you have to bargain with the union over. You can't just unilaterally impose one of these grids or one of these policies, correct?
Correct. And because they are now a mandatory subject of bargaining, like we talked about, those are things that you have to discuss with the union, and it's one that if either side brings up in bargaining, you cannot refuse to bargain over it. So what are some of the labor impacts to this? Again, it's only applies to contracts entered on or after the effective date. The guide or the matrix is now a mandatory subject of bargaining. So what about midterm bargaining? You know, do I have to, or can I as an employer initiate bargaining? Should I initiate bargaining? You know, I think we talked about this, Diana, and with the language of the bill that says that this bill only applies to CBAs entered into on or after the effective date. I'm not sure if we can initiate midterm bargaining if our contract still has 2 years to go.
I think it will be an interesting question, and if it's something that the agency is interested in doing, I really do encourage them to contact whoever represents them in their labor matters, because I could see an argument, Mark, especially based on that recent Multnomah County midterm bargaining case, where I might be able to, as an employer, go forward. So I think it's an open question, but I've got to tell you. So I guess I'm kind of a pessimist, you guys, on 1604. I see too many loopholes in it where an arbitrator is going to be able to get out of it. I don't see a lot of unions agreeing to these matrix without a lot of wishy-washy wiggle room in them. And remember, if you can't solve an issue with a law enforcement unit regarding a mandatory subject of bargaining, where do you go? You go to arbitration. So, I mean, I think it's a good step. I don't see a lot of promise in it, to tell you folks the truth. But it's one of the bills they're considering for some limited reformation in the second session starting on Monday. So we'll see. But again, I tend to be a little bit of a pessimist. Mark, are you done with that slide, or should
Yeah, I think we can. I think we can move on. I mean, the last one is there. You know, if you already have a guide or a matrix, you know, this bill is only going to apply if that guide or matrix you have was established through collective bargaining, and then the CBA, of course, has to be adopted
and
on or after that's effective date.
There are a few matrix I've seen. I know at one point Portland had one, at least for, I think, their fire. Now, how effective it was, you know, that remains to be seen. But yeah, all right. Well, thank you. So let me add just something on 1604. One of the interesting things I saw was, you know, I was a deputy district attorney for the first 14 years of my career. And in this situation with 1604, state prosecutors even went in and added their support for the bill. And the Oregon District Attorneys Association, which represents all of the district attorney's offices in the state of Oregon, joined along with the state police chiefs, the Oregon Sheriff's Association, and the bipartisan coalition in the legislature, and they all urged Governor Brown to pass that bill. Well, she doesn't get to pass it, but in other words, to sign it when it had repeatedly failed before. So it was interesting to see sort of all of these groups coming together to rally against the bill. I wish it had a little more teeth. So Mark, why don't you tell us about 4205?
Yeah, so the duty to intervene and report, this is probably the second bill with the most labor implications. This bill requires a police or reserve officer, without regard to rank, to intervene or stop another officer in any act the intervening officer knows or reasonably should know is misconduct unless the officer cannot do so safely. And we'll get into the definition of misconduct, but I find it interesting that this is without regard to rank. Intervene was not defined in the bill, so, what does intervene mean? Is one question that I would have. Yeah, so the reporting as soon as practicable, but no later than 72 hours. And then here's the definition of misconduct, which I think is pretty broad. We don't need to sit here and read all these, but this is the misconduct that an officer now has a duty to intervene or to report if the officer sees this. And failure to intervene or report is now grounds for discipline by the law enforcement agency or grounds for DPSST to suspend or revoke.
And that's an or, not an and. So DPSST could conceivably act on their own.
So let's get to the labor impact here. Is there a duty to bargain? Well, this is a new law. So I guess I don't see a pressing need to bargain over this now that there's a law that says the officer is required to intervene in those certain areas of misconduct. Again, if you get a demand to bargain over it from the union, of course, process that. Of course, contact your labor council. You could consider adding it to a discipline guide or a discipline matrix through collective bargaining. And then here's an example that when I first read this is what went through my mind is, you've got a first year brand new officer who sees his superior, his captain or his sergeant engaged in those 5 areas of misconduct, but does not intervene because he or she is a brand new right out of the academy, doesn't intervene. Are you going to discipline this new probationary officer for not stopping his or her superior? And then, okay, so then there was maybe a failure to intervene. Do we have to prove the underlying misconduct occurred in order to have the discipline for not intervening hold up? I mean, I guess I don't have the answers to these questions, but these are the questions that are the red flags in my mind. What happens
if I can just sort of interject,
Yeah.
not that I have the answers, but as always, I have an opinion. And yeah, I would think you would have to prove the underlying misconduct as well as the no intervention, because if you don't have the misconduct, you don't have the obligation to intervene. I would also, on the probationary new employee, it just sort of emphasizes for me that even though 4205 is going to be a new law, I think you need to do some training. And I think you need to send this out to your officers and say, here's 4205, here's what it lists, read this, maybe add it to your policy manual, something like that.
Right, because notice, of course, is part of the just cause for discipline. So absolutely right. And then as I was kind of still going down this rabbit hole, what happens if an officer reports the misconduct, but did they intervene? Now we've got somebody coming forward to the chief or their captain or whoever and saying, I saw Officer Smith, engaged in this misconduct. I want to report it. Is the next question, well, why didn't you intervene? Now, is that eyewitness to the misconduct now potentially subject to discipline?
Well, and interesting too, because you're going to be doing simultaneous investigations. You also have to investigate the officer who engaged in the misconduct.
Right. And then further down that rabbit hole, Officer Smith will say reports the misconduct and says, Officer Johnson also witnessed it. Well, Officer Johnson then didn't intervene and he didn't report. So now do we have 3 investigations going? I mean, it seems like there are maybe some unintended consequences to this bill, as now these eyewitnesses who were there to corroborate the misconduct that was observed are now potentially under investigation themselves.
Yeah, and so we're going to keep moving on. We've only got about 10 minutes left, you guys, but I do also want to flag here that another area of concern I see in this bill is protected, privileged communications between union stewards and the people they represent. So that's another place you're going to really want to contact your labor council about. So now let's just talk briefly about Governor Brown. On the heels of all this, announced a new police training task force. They're charged with recommending improvements in the training and certification of Oregon police officers. That's moving forward. The task force is going to provide recommendations on incorporating use of force training, racial equity, etc. So Mark, let's talk really quickly about, well, not really quickly, I'm sorry, that was too much pressure. Mark, tell us about House Bill 4207.
Right. So there's, I'm not sure the labor impacts on this, but it requires DPSST to establish an online database accessible by the public. The information published will include the officer's name, the name of the agency, and the basic facts leading to the suspension or revocation. And then DPSST will publish that, after the appeal process has ran its course.
Yeah, and ladies and gentlemen, is this not a long time coming? I mean, my gosh, trying to get information about an officer's DPSST cert history, et cetera, or the outcome of a case has been very difficult. I was very pleased when they reformed the F4S form a number of years ago, and I think this is a logical next extension, and I sincerely welcome it. So now let's talk a little bit about how use of force is going to also be reformed pursuant to these bills. Mark, tell us a little bit about the chokehold ban.
Right, so the chokehold ban, modifying Chapter 161, the criminal law statutes. So the law now provides that it is not justified or reasonable in any circumstance for a police officer to knowingly use force that cuts off the breathing or circulation of another person on the throat or neck, unless the circumstance is one in which deadly physical force could be used.
And it's my understanding that's one of the bills that they're looking at maybe reforming and getting rid of that exception about you can still use a chokehold if deadly physical force was authorized.
I believe I read that too, that there's talk of making it an outright ban. Is that right?
Correct.
cutting out that
yeah, that under no circumstances will you
right.
use a chokehold ban.
Right.
Or ban, sorry, not banned, ban. Yep. So labor impacts on this bill, what do you think?
Well, I mean, now it's a violation of criminal law to do this, so it doesn't seem to me like there's a big impact. Again, providing notice, providing some sort of, training or announcement, if not already done, that the chokehold ban is a ban, is probably worthwhile. The use of tear gas, I think, is kind of similar to the, as far as labor impacts, similar to the chokehold ban. The use of tear gas is now prohibited, except in circumstances constituting a riot. The bill requires the law enforcement agency to take these steps prior to using tear gas. You must announce the intent to use tear gas, allow time for individuals to leave the area, and then announce again a second time immediately before using the tear gas.
All right.
And I guess
on
that, we just bargaining. I mean, again, it's similar to the chokehold ban. I mean, it is the law now. So announce it, put people on notice, if not already done, that the use of tear gas is affected by this recent bill.
And, under most law enforcement departments have a general policy that it's a violation of policy if you commit a crime or violate a criminal law. So that might be a very easy in for keeping it internal when you need to. All right, so then also I was reading down here in the Eugene Registered Guard, Eugene Police also ended what was known as the carotid restraint. And it's a maneuver. It's like the chokehold, but it's not the same thing. Now, again, this one is allowed if you're also authorized to use deadly force. And it's one of few reforms that Eugene Police Department continues to promise in their reformation efforts. So we've only got a few minutes left. Let me talk real quickly. So I've had a few clients who have gotten these public records requests from various citizen action groups regarding their police officers. They say that the department knows or have engaged in dishonest or untruthful or unprofessional behavior, as well as those who have used excessive force. If this happens to you, again, contact your legal counsel. There are various exceptions in the public records laws that would not require you to respond. There are some that would require you to. You might have to do some redacting. If some of the records requests we've gotten sort of seek out the city's opinion, you don't respond to opinions in a public records disclosure request. So the first step is to acknowledge the request.
Diana, so we're just about done here. So hopefully everybody's still on. Looks like we've lost our PowerPoint, which I believe you guys will get a copy of, but public records request, real quick here before we end. Acknowledge the request, depending on whether or not you actually have the responsive records. Again, then send the second letter. You can provide a cost estimate to provide the documents, list the applicable exceptions. If you do have the records, then a fee estimate would be due within the additional 10 days. Again, this is nothing new. Follow your public records policies and the Oregon public records law. Moving on, I guess that's about it. So then you need to finalize the public records request, or you need to complete the request, which is either to provide the documents or provide the exceptions to not providing those documents. And you can do that with a final letter letting the requester know that the response has been completed. So that was it. Thank you for your participation. I don't know if we had any questions come up in the chat. Looks like Diana just tried to reach out to me. So we'll see if she's gone. Are there any questions, comments? Yeah, Diana's internet failed. So at least we got through all but one slide. Thank you all for joining us. And I don't see any questions, but where's that chat? And Lisa, are you still on here?
I am still on here, yes.
I don't see, oh, there's a comment that says, thanks. So hope this was helpful. We hope this provided some at least some opportunities to spot some of the red flags that might come up during these larger policy discussions that you all are having. And of course, nope. Somebody has a question.
So it's Pierre. Pierre, if you can unmute your line, you can go ahead and ask your question.
There we go. There it is. Sorry. Hey, Mark. The statute on establishing the public database of suspensions and revocations of police officers also includes a new law requiring law enforcement agencies before offering employment to request and review the applicant's personnel records from all law enforcement agencies in any jurisdiction at which the applicant was formerly employed. I don't see a duty to bargain there, but did you have any comment on that that new law? And it also imposes a duty on to request and a duty on Oregon law enforcement agencies to honor the request by giving over records of employment of job applicants.
Yeah, so I guess I don't know where the bargaining obligation would fall there.
I'm not seeing one.
Unless it was, you had a contract provision that I guess somehow addressed that, and that specific contract provision would be impacted.
I suppose conceivably the common provision that, I mean, where personnel actions, adverse personnel actions get removed from the file after a while. I mean, on behalf of departments, I might be interested in bargaining that, making it clear to the union and trying to get it into the agreement that the employer is nonetheless bound, even if for purposes of, you know, progressive discipline, you remove a written reprimand or you remove an adverse employment action or a demotion or something like that, that the employer is still going to be duty bound to obey this new law and forward that information elsewhere. That may have been the case anyway, you know, but
right. That would probably that would be one thing that would be good to make clear that yeah, I mean, if you remove the reprimand after so long that it cannot be used for progressive discipline purposes, but maybe dispersed pursuant to this law. So
not a big deal.
Yeah. But well, unless there's anything else, we will let you go, and thank you all for attending.